Get started right on time so that we can make sure to answer all of your questions, and feel free to leave questions in the chat or in the Q&A, and we will keep track of those, and we'll just answer questions kind of as they come in. We want to make sure that we're able to get everybody's questions answered as much as possible. So today we are going to be talking a little bit about pretrial procedures and trial practice in municipal court. And we're really fortunate to have with us Attorney Kori Ashley and Judge Jim Gramling. I'm just going to give a little bit of information about both of our wonderful speakers today. Judge Gramling gave a great presentation in part one, if you were able to make it to that, of this training series, and is going to talk today about pretrial and trial-related issues in municipal court. Judge Jim Gramling graduated from the University of Wisconsin Law School in 1971. He then worked at Legal Aid and Defender Society of Greater Kansas, Missouri until 1977. And then he was at Legal Action of Wisconsin until 1986. Judge Gramling then successfully ran for the position of municipal judge in Milwaukee and was reelected a number of times until retiring in 2007. Since that time, he's worked as a volunteer attorney as the Center for Driver's License Recovery and Employability in Milwaukee. And he's a member and past president of the Wisconsin Access to Justice Commission and a board member of the Wisconsin Justice Initiative. So we are really excited to have Judge Gramling back with us today. We also have with us today Attorney Kori Ashley, who was born and raised in Milwaukee, Wisconsin. She completed her undergraduate education at DePaul University, where she received a bachelor's degree in political science. She received her JD from the University of Wisconsin Law School in 2012. And after graduating, Kori practiced criminal defense law in various counties in Wisconsin. She's currently a public interest attorney at Legal Action of Wisconsin, and she works in the Milwaukee office in the Road to Opportunity project, assisting clients with removing barriers to employment, housing, and educational training opportunities. Kori is a member of the Wisconsin Association of African American Lawyers, the Milwaukee Bar Association, and sits on the Eastern District of the Wisconsin Bar Association's Board of Directors. And in October of 2017, Kori participated in the Shriver Center's Racial Justice Training Institute, a national leadership program grounded in its commitment to race equity as an integral and essential part of anti-poverty advocacy. In 2018, Kori was named Attorney of the Year by the Wisconsin Association of African American Lawyers, or WAL. And in June of 2019, she was elected as the chairwoman of the State Bar Board of Governors. Kori was recently appointed to Branch 19 of the Milwaukee County Circuit Court by Governor Tony Evers in June of 2020. And she lives in Milwaukee with her husband and her adorable one-year-old son. I'm grateful that I've been able to witness all of Kori's amazing work since we went to law school together and we're in the same graduating class. So I'm thrilled to introduce her here today. And then Kori, I will let you take it away from here.
Thank you, Emma. I really do appreciate it, and I'm excited to be here to provide what we hope will be some hopeful practical skills for those who have stepped up to assist individuals who have been cited with various things in both City of Milwaukee, municipal court, and municipalities across the state. I will just start off by saying that some of these things will be City of Milwaukee specific, and I will try to articulate that when that is the case, but the statutes and things that we'll talk about will be applicable to citations issued elsewhere. So yesterday, or on Monday, you had part one, which covered the municipal court, a broad overview, constitutional rights. Today, we're going to talk about substantive pretrial matters and trial practice. And on Friday, we're going to talk about post-judgment matters along with attorney Susan Lund. So just to kind of take a snapshot of a municipal court case, where you start. The case is going to start with your client's alleged violation. They will either receive a ticket in person, an arresting officer can hand a citation to an individual, or they will receive a citation in the mail. And at that point, they will get an initial appearance date, which we'll talk about in more detail. That initial appearance date will trigger timelines. So you'll have your substitution deadline, which you'll find in Chapter 800 of the statutes, which is the municipal codes. It also triggers your ability to get discovery, which we're going to talk about in more detail today. You then, under the timeline, are going to have a pretrial conference where you'll attempt to resolve the case with the city attorney. And then after that, if no resolution can be reached, or if your client wants to proceed to trial, then you have the trial. So what happens at the initial appearance stage? At this point, your client has received a ticket alleging, or what it should allege, is some violation of the ordinance code. There is going to be a date on the top of the citation, on the top left, which indicates that your client has to appear on a certain date in order to contest the citation. Failure to appear on that date could result in either two things: a default judgment, where your client is automatically found guilty of that citation, or a failure to appear warrant could be issued. When talking to clients, I always, you have some clients who will, because these matters are civil in nature, when trying to justify why these cases matter, you want clients to take care of these things because you don't want clients to have unnecessary future contact with law enforcement. In these cases, we're representing individuals who are protesting. Say you fail to appear for one protest citation and you're out protesting again, perhaps you have a warrant issued for you and law enforcement has a lawful reason to have contact with you. So if ever you have to justify taking care of these matters, that's one way to spin it. The first thing that you really want to do is make sure that your client enters a not guilty plea on behalf of that citation. You want to appear and contest that citation. You can do that in a couple of different ways. You can appear in court on that date that's listed on the citation and enter a not guilty plea on behalf of your client. You can submit a plea by mail up to 5 business days ahead of that appearance date. You can also, for City of Milwaukee, you can do it online through their website. You can also do it by fax. You want to plead not guilty, and then what's going to happen is that case is going to be set for a pretrial conference, which we'll talk about in more detail in a couple of slides. Things to consider at this point. You're going to get the citation, and one of the first things I do is determine, okay, is this a case where I might want to be raising a couple of different things. The first is any constitutional issues, right? We talked about that in the last presentation on Monday. The other thing is to reference Chapter 800 sub 2 to make sure that your citation is statutorily sufficient. There are a couple things that need to be in a citation in order for it to be to have appropriate probable cause. And the big thing that I look for is, does this citation actually allege a violation that can readily be understood, which is what the statute requires. If there is a statute, or if there is a citation that does not properly allege the elements, you might want to bring a motion to dismiss. And at this point, you can do so by, when you file your appearance, you can indicate that you'd like a date to challenge the sufficiency of the citation. So that's something that you want to do up front, and you should be considering right away at the initial appearance stage. The other thing that I would be considering at this point is competency. I know Judge Gramling talked about competency and the appointment of a guardian ad litem on Monday, but I again want to reference you to Chapter 800 035 sub 2M, which indicates that if you have questions about your client's ability to understand the proceedings, if there are issues regarding their capacity to assist in their defense, this is something that can be raised. And what happens is the court has to appoint a guardian ad litem to make a determination on that issue. Practically in Milwaukee County, when you raise competency, essentially if you can put forth reasonable documentation that your client is suffering from mental health issues, or was otherwise has some cognitive limitations, those cases are typically dismissed. So this is something that you really want to be considering at an early stage. It's another way to advocate for your client. I want to also just talk briefly about virtual appearances. We're in the age of COVID. So particularly in Milwaukee, everything right now, they're trying to do everything in their power to limit the number of persons coming into court. So you really want to take advantage of faxing in your not guilty plea, doing that online. to avoid an unnecessary court appearance. Milwaukee County is also doing virtual appearances. So if your client receives a ticket, you can call the line and ask to be registered by email so you can appear via Zoom, so you don't have to appear in court and are just aware of some things that are going on as a result of COVID. This is actually what a citation looks like. This happens to be a state of the emergency curfew citation. As you can see on the top left-hand corner, there is a date, that November 3rd, 2020 date. That is the date that you have to return for that initial appearance that we discussed. You have to return on that date and appear and enter that plea to avoid either a default judgment or a warrant being issued. There's also the deposit amount that's on the top right-hand corner of the citation, indicating the possible penalty for being found guilty of that forfeiture. Trying to think other things that we might want to point out here on the citation. It also tells you where you need to report. You're coming to the City of Milwaukee Municipal Court. That's obviously going to be pertinent. It's telling you the ordinance that is violated. In this case, it's found in the Milwaukee Ordinance Chapter 6-7-3. Very often, the ordinances in Milwaukee County parrot state statutes, and so that would also be, for disorderly conducts, for assault and battery. They're also going to be listed on this statute, so you have an idea of what you're actually defending against. This statute does not, or this citation, excuse me, does not contain the probable cause statement. We're going to talk about how you go about getting that. The other thing that's triggered after your initial appearance date is discovery. Obviously, you want to, at the very early stages, figure out how you are going to advocate for your client. And so you need to get the citation that contains the probable cause statement. Why was your client issued this citation, and what evidence does the city have to satisfy their burden in court? You need to file this request, and I typically do so as a matter of course when you file your initial appearance. In the City of Milwaukee, there is a form. It's a form discovery request that's available online. I would use that form. It essentially just states that you are seeking the probable cause statement. You're going to submit that to the court. You're going to copy the city attorney's office, and then their office will forward you the citation that contains the probable cause statement. You have 30 days to file this request, and it's your only right to pretrial discovery under the statute. In Milwaukee, you also want to consider submitting an open records request. And I say consider because keep in mind that your client does not carry any burden in these cases. The city attorney's office does not maintain the video or body cam footage, photos, more elongated police reports. That information you are going to have to obtain from the Milwaukee Police Department directly. They have an open records process. It is, again, a simple form request that you can go to online through their website. Key to know about that process is that it does take, I would say, upwards of 90 days to get body cam footage, photos, and those longer police reports, which include the CAD printouts. That's something that you want to let the court know ahead of time, ideally at your pretrial conference, which we'll talk about next, so that when scheduling your case, you are able to take that lapse in time into account. There is one case on point that's included in the materials regarding discovery. For failure to provide it, does a court have the authority to dismiss a case as a sanction for not providing discovery? It does, but they have to state reasonable reasons on the record, and the case has to be egregious. The way discovery works out practically, if you're having issues getting discovery from the city attorney's office or from MPD in Milwaukee County, you raise it at an adjourned pretrial conference or at a pretrial conference, and the judge typically nudges the city. And it's been my experience that you get discovery soon after, but you do want to plan for that because it can be a significant delay on a case. One thing that I didn't mention is these are civil proceedings. And so when I say appear, your client never has to appear for these proceedings. You can appear on their behalf. So your client does not have to come to court with you if you're going to go in and plead not guilty in person. They don't have to appear at these proceedings unless, of course, there's a trial on that matter and you want them there. The pretrial conference. After your case is, after you enter a not guilty plea, your case is going to move to a pretrial conference stage. And it's an opportunity to really tell your client's story. This is your opportunity to get in front of the city attorney, and we're typically asking them to dismiss, right? But it's an opportunity for you to tell the city from your client's perspective what happened and why this citation should not have been issued. There are a lot of things that you should consider before going into a pretrial conference. It's ideal to have already had discovery, to have at the very least your probable cause statement with your narrative. So you can really, for me, I don't like going into the pretrial conference and learning new things. So I like to have a detailed conversation with my client prior to that. I like to have the probable cause statement so I can really be telling the prosecutor new things as opposed to hearing new things. You can do logistically pretrial conferences, and it's encouraged in Milwaukee now by phone or by email. You can reach out to the city attorney's office at any time and say who's taking cases and who's the city attorney assigned to branch 1 or branch 2 or branch 3, and they'll provide their email address. So you can do this ahead of time, again, to avoid an appearance in court, and due to COVID, to limit the number of persons that are in court. The things that you want to consider are your client's case on the merits, right? You've taken a look at the statute and the ordinance at this point. Is your client a juvenile or an adult? And I bring this up because it's been my experience, particularly in Milwaukee, but also in other municipalities, that folks don't want to needlessly see young people have conviction records, which these are, unnecessarily, particularly if it's their first time receiving a citation. So there are ways that you might advocate for a juvenile or an adult who has no prior civil record, raising those sorts of issues. This is a young person. This is the first time that they've ever been in this court. Let's talk about what happened. We've already talked about whether or not you want to consider any constitutional defenses, particularly in these types of curfew-related cases. We've raised the sufficiency of the citation. Are you going to be arguing that it's insufficient? That the violation is not stated readily in a language that can be understood. There's no probable cause. It's not sufficient. The other thing that you want to consider is who would the city's witnesses be at a trial in this matter? Many trials in the city of Milwaukee do not move forward because they rely on lay witnesses to come to court and give testimony. And that's a difficult thing to do, right? To ask individuals who might be working to come to court at 8:30 or 1:30 and present themselves for a case. It doesn't happen often. Many of the cases that I set for trial are ultimately dismissed because of a city's inability to get their key witnesses to come to court. So if you have a case that's a disorderly conduct or any case really that relies on a citizen witness, this is something you want to talk to your client about. And I don't want to say, sometimes we factor that into our decision on whether or not we want to set something for trial, because you might have an absolute ability to beat something by virtue of the city not being able to make their case. And so it's something you should consider. Are we looking at an officer witness? Are we looking at a lay witness? Police officers come to court. And so that's something different to consider. You also, at a pre-trial conference stage, want to think about what's called a deferred prosecution agreement. It's often commonly referred to as a hold open agreement. And what that is the opportunity for someone who typically does not have a prior civil record, but they can be negotiated in other circumstances, to enter what's called a conditional no contest plea. The court will accept their plea and they will withhold judgment for a period of time. And if this individual does not receive any additional tickets they can be traffic related, but tickets, non-traffic related tickets, if they're successful, the court won't enter that judgment and the case will ultimately be dismissed. That's something to consider, particularly if you think you might have some issues on the merits of a case. If you have an individual who just does not have time to come back to court for a trial and perhaps doesn't have a prior record and says, look, I'm not going to get in any trouble. This is not going to be an issue for me to be successful. This is something that's attractive for me. They're commonly used for juveniles and for individuals who do not have prior convictions. The one thing that I would consider when doing deferred prosecution agreements is getting a short period of time. I think sometimes the city asks for a year, counter with 6 months, right? The shorter the better to get your client, from under the thumb or from this hanging over them. There's still an opportunity to advocate for your client at that stage. And again, in arguing for or advancing a deferred prosecution disposition, you want to talk about your client's life, what they're going through, the things that might have occurred up into that case. All of these things the city will consider when determining whether or not this is an appropriate disposition. The one thing you should know is that even though a case is dismissed, typically the client will still owe $60 in court costs. And that's currently the case in Branch 2 and in Branch 3. In the city of Milwaukee, Branch 1 does not do court costs. So that's something to consider. If you have a DPA in that court, your client will avoid having to pay court costs, at least at this time. But then there are other alternatives. You can ask the court to permanently stay a court costs or even forfeitures due to poverty, which we're going to talk a little bit about on Friday. So it's something that should be considered when looking at your client's record, the merits of the case, and what a trial would look like on the merits. Just some practical tips too for dealing with City of Milwaukee and pretrial conferences. Oftentimes, most citations are negotiated down. The best offer I think sometimes you're going to get on non-traffic related citations is a disorderly conduct. So don't be surprised if that's the case. If you're looking to get pure dismissal and you're not able to do so, arguing that the citation is statutorily insufficient or that there's a constitutional violation, know that in bargaining, DC might be the best offer unless you're willing to take it to a trial. That's not uncommon. If you happen to have a client who has, for example, a retail theft citation, there is a course for first-time offenders that they can take at UWM that's offered. And if they complete that course, the court will dismiss the citation. However, that course is $100 and it has to be paid up front. So clients who have some inability to pay issues, that might pose some practical issues. And then for clients who have issues with possession cases, paraphernalia cases, there's also a drug course at MATC. That course is $17. You can have prior drug offense convictions, and usually the city attorney's office is amenable to allowing your client to enter into an agreement to complete that course in order to get a dismissal disposition. So just certain things to think about when you are negotiating with the city attorney.
Kori, could we go back to a look at the curfew citation and
Yes.
And come back to the question of sufficiency of the citations? This is an example of something that attorneys will see resulting from the protests, although some of the curfew cases are being dismissed, we're told. But I want to point out, as Kori did, what's on this citation and what's not. The statutes require certain things to be in this, and it's mandatory that certain things be on the citation. And section 800.02 sub 2 lists all the things that have to be stated in the citation. Among them is, what's the violation? Okay, this one says state of emergency curfew. But then separately in 800.02 sub 2 is a requirement that there be a description of the violation in language that can be readily understood. And nowhere on this citation is there that. There's no indication of where, what happened, when the curfew was called. I think the curfew did have a moving goalpost. I think there were different times at different nights, but in any event, there has to be that description in here. And that's a very important requirement. As Kori indicated, you can get the probable cause statement through discovery, but the statutes require that that information be provided to the defendant earlier than discovery, and it could provide a basis then for challenging the adequacy of the citation. Generally, that space where it says agency space, do you see that, Kori, from time to time, where that's where they'll put in the description that tells you
Correct.
more about what the probable cause is. So that's the space where you would ordinarily look for it. Thanks.
Yes, and there's one related question too to what you were just talking about too, Kori, is does a hold open deter the individual from engaging in future protests? How might you think that might influence what an individual is able to do in the future if they get one of these tickets?
I think that, I think it certainly could, knowing that you have, and I apologize if there's interference in my background, but knowing that, you have a certain period of time where you can't get any future citations, or you are going to, your conditional plea of no contest is going to be accepted. I think that could very well be a deterrent to participating in future protests. I certainly think that's something to talk to a client about, and how they would feel moving forward. If they accepted this sort of disposition. I think everyone's position is going to be different. You might have a client who says, look, I'm going back to school, or I'm doing X, Y, and Z, and I just don't want to, think about this, it works for me. Or you might have some that say, for that reason, that this is not an acceptable manner for me to resolve this.
Any other questions, Emma, before we move into the trial part of this?
No, I think it's a great time to move on to that.
Good. I'll take the baton from Kori then. We're going to talk a bit about how trials function in municipal court. For those of you who are veterans of trials in circuit court, you will find that the trials in municipal court are less formal, and there may not be a lot of new information for you here, but let's find out. I want to just point out for practitioners in circuit court that chapters 801 to 807 do not apply in municipal court. There's a temptation, I think, when trying to figure out, okay, what procedures apply in the cases that you might be handling in municipal court, to look at the chapters of the statutes that are familiar to you, procedurally speaking. But 801 to 807 do not apply in municipal court, with a couple small exceptions. In chapter 800, which is the chapter that covers municipal court procedures, there are a couple references to those earlier chapters in the 800s of the statutes. For example, how to calculate time in municipal court borrows from circuit court 801.15. And then in the reopening sections that will be discussed with you on Friday, there's a borrowing of section 806.07, which provides a fairly expansive basis for reopening. So generally speaking, 801 to 807 do not apply. Look to chapter 800. Now let's look at how you get witnesses to court. How do you get them to appear in court, assuming you have some witnesses that you want to present at trial? First off, and I mentioned this on Monday, it's a bit odd for attorneys that practice in circuit court, but the subpoena has to be issued by the judge in municipal court. So you can't just prepare a subpoena, fill it in, have it served on the witness. The form itself has to actually be signed by the judge before it's served. There's a form available. The reference was made on Monday, and I'll make it again today. In your materials, there's the municipal court bench book, and there is a form available in the bench book for subpoenas. Also, as noted here on the slide, Milwaukee Municipal Court has a great form, a great subpoena form online. So you just go to the municipal court website, look at the forms, and you'll find the subpoena form there. But again, it has to be issued by the judge. And then when served, as you know, perhaps from your experience, you have to serve along with the subpoena the witness fee. One of the reasons, and Kori mentioned that witnesses often don't appear, citizen witnesses often don't appear in municipal court. Maybe one of the reasons is they don't get paid much. The witness fee is $5 to show up in municipal court, and mileage, and the court typically orders $2 for the mileage for the transportation expense. So somebody's going to get a $7 check for spending potentially 3 or 4 hours in court plus some travel time. But you have to, if you are going to serve a subpoena, you've got to serve it along with the witness fee. In Milwaukee Municipal Court, $7. I will also make note of the provision in Chapter 800 that allows witnesses to appear by telephone or video. There is a section, it's 800.085, that gives you the opportunity to present your witness by telephone. By video might be a little harder, although the courts are getting so used to using Zoom now that maybe there's a way to do it. I don't know if they're equipped to do Zoom. Kori, do you know, are they equipped to do Zoom in the courtroom, or is it generally done in chambers, do you know? Oh, you're muted.
At this point, I think it's from chambers. I've not seen it in the courtroom at this point, but it seems to be a moving target. It seems to be different every time I check.
I think they're changing all the time. So you can, though, get permission for a witness to appear by telephone. The section of the statutes that I mentioned, 800.085, indicate that you can stipulate with the city attorney, or you can, if the city attorney doesn't want to stipulate, you can move the court, and there is a whole list of standards that are to be applied, taken mostly from a circuit court statute. But anyway, there's a way to get a witness there. As we note here, I do need the previous slide. Thank you. As we note here, assume that your client will be subpoenaed by mail. The city, in all likelihood, will issue a subpoena for the defendant to appear. They think that they can build their case more easily if they have the defendant there to testify. I will say that in Milwaukee, the way subpoenas are issued typically out of the Milwaukee Municipal Court is they're issued at the request of the city attorney, and the court approves it, but they mail them out. And when subpoenas are mailed, they're not sent by certified mail with any requirement of return. I don't believe so, and Kori, if I'm wrong on that, let me know if it's different. But yeah, so to know whether the witness actually got the subpoena is questionable, and I'll mention something about that later, why that could be important. But oddly enough, your client might be subpoenaed, and this goes back to the point raised Monday, we'll raise it again today here, that there's no right against self-incrimination, and the city attorney can subpoena your client, the defendant, to appear at the trial, can call the defendant adversely, can grill the defendant. This is all permissible because it's a civil proceeding. The standard of proof for conviction in municipal court is important. The city has the burden of proving by evidence that is clear, satisfactory, and it used to be just plain convincing, but it was changed a bit back to say convinces the judge to a reasonable certainty that the defendant committed the violation. So those words are very important. They set a high standard. It's not preponderance of the evidence like in civil cases. It, of course, is not quite what the criminal cases require, but it's a very high standard nonetheless. And every opportunity you have to remind the judge how high that burden of proof is will be to your client's benefit. The rules of evidence do apply in circuit court. So you will be applying the rules of evidence, chapters 901 to 911. There's an exception for proceedings involving juveniles. So that's that reference to section 938.17. But otherwise, the rules of evidence do apply. So be prepared to have those rules of evidence in mind or in front of you. The next thing we want you to be aware of with respect to trials is that the judge has the authority by statute to amend the citation after hearing the evidence. So you've got an evidence charge, a citation charging something, and you have the trial, and the judge listens to the evidence and decides, I don't think it's quite that. It's not an assault and battery. And as Kori suggested, it might be amended down to a disorderly conduct, because that's the resting place for a lot of these things that come in as a more serious charge, and there's a decision to amend them because disorderly is such a broad category of violation. I want to just give a quick example of a case that I had that shows how this works. I had a case a year and a half ago tried in one of the Milwaukee Municipal Court branches. A young man who was a reporter for the Neighborhood News Service was charged with trespass by going onto a parking lot at the District 2 police station. He was working on a story, and he drove into the parking lot in his vehicle and parked it, and then was going around taking pictures of police vehicles. There was no sign at the entry to the parking lot that said no trespassing. It did say you could only municipal vehicles were permitted in this lot. So we thought we had an awfully good case to say that it wasn't trespassing. And we went to trial on the case, and the judge heard the evidence. In the end, the judge ended, I thought we had a winner. The judge decided, well, I'm going to amend this to a parking violation. So it's a rather odd kind of amendment when you've got a charge of trespassing and it goes to a parking ticket. But there was a basis for that amendment, and my client was happy that he didn't have the stigma of a trespassing charge on his record. And I just give that to you as an example of how this can work. One more thing before we leave this slide. I'm sorry, I should have let you know, Emma. Kori mentioned the substitution of judge, and that is a option that you have, very short time window to request a substitution, 7 days from the initial appearance. There's a second point at which a substitution can be considered, and that is where on the day of trial, you appear to defend your client, and there's a different judge sitting. If you have not been given notice ahead of time that the new judge is going to be sitting to hear the trial, you have the option of requesting a substitution at that late date. So it's in Chapter 800, and this can be significant. The judges in Milwaukee Municipal Court do take off from time to time, and they have substitutes sitting, some of whom are not perhaps as open to hearing our defenses as others. So you need to be aware that, of course, you want to consult your client. You want to spend time coming back again, but it's something to consider. And Susan Lund just prompted me on a question here, and that is, or a point, and that is that if you do file an appeal after losing in the municipal court and the circuit court reverses, when you come back, you have the right to substitute on the judge who ruled against you the first time around. So the substitution right is significant in municipal court and is an important one to be aware of. So on the next slide, we're going to talk a little bit about the actual trials. They're all bench trials. It probably wouldn't surprise you to know that there are no juries in municipal court, no jury box. It's just the judge who makes the decision on everything, which can be important if there are 3 police officers testifying and staring at the judge as the judge is making the decision. There's a different dynamic from having a jury retreat to a jury room and discuss it in private. But they are all bench trials. On appeal, should you have to appeal to circuit court, you do have the right to request a 6-person jury. So there is an option down the road of a jury trial if you lose in municipal court. Just some basic common sense type things here. Again, those of you who have lots of trial experience are not going to be surprised to see that you want to remind the judge of the burden of proof in your opening statement. You want to let the judge know about some of the facts that you intend to prove. And this can be important because the judge in all likelihood, won't have much knowledge about the case itself, unless you've peppered the court with motions in advance. The judge otherwise is not going to have much information about the case. The probable cause statement that Kori mentioned is available through discovery. It's actually a alternate version of that citation that we looked at earlier. And that citation has the description of the facts of the case. And then there often can be officer's notes that are in the file as well. The judge is not allowed to look at any of that before hearing the evidence at trial. So, and I think the judges are good about that. But I say this so that you know, the opening statement might be the first time the judge really is hearing about what happened. So use that opportunity. The judge might not invite you to make an opening statement, but you know, judge, I'd like to make an opening statement. You of course want to avoid engaging in argument in that opening statement, and highlight that burden of proof. I don't think Kori and I can mention that too many times. We want the judge to continue to be reminded it's a high burden. Those are some initial points that you want to consider about the trial. As the trial proceeds, there will of course be an oath or an affirmation offered by or administered by the court. In Milwaukee, I'm not sure about the other municipal courts, but in Milwaukee, often the clerk actually administers the oath or affirmation. You might just want to clear with your client ahead of time that your client is willing to take an oath, because if an affirmation is required, you'll want to alert the court that your client will not take an oath. So that's important. With respect to cross-examination of the city's witnesses, the municipality's witnesses, I should say, some of these are villages or towns, but in cross-examining, of course, you want to use leading questions. You want to keep the control of the witness to the extent you can. Make the questions clear and simple so that the judge knows the facts that have just been established through your skillful cross-examination. I want to just mention one quick thing, and I don't know, I'll invite Kori or Emma to comment on this to see if they have any other thoughts. But picture the police officers who are going to come into court at the time of trial. They will show up because they get into trouble if they don't, and they also get mandatory overtime for showing up. They might leave after 30 minutes if there's no trial, but they're still going to get paid. There used to be 2 hours. It might be a little less now, but they used to get 2 hours of automatic overtime just for showing up. So they'll show up. You can expect that your officer might not have a darn bit of memory about what happened and has not brought his or her little notebook along to refresh the memory. What often happens is when they arrive in court, the city attorney will hand them the notes or description of what happened, and then they'll sit down in the chairs and start reading it over so they can remember what happened. I bring this up because it helps to define that line between any present memory the officer has of what happened, any refreshing of memory that's occurred, and sometimes they can't even get their memory refreshed. And you might want to be prepared then on your cross-examination of the officer to get into that a bit. You know, you might say, I saw that the city attorney handed you your notes when you arrived here today. You really don't have any memory of this event, do you? You know, you'll decide, you know, you're the trial attorney, but there is something to be made of that oftentimes if you have a good reason to believe the officer really doesn't remember it. And that could be very true in these protest cases, because for them to distinguish, first of all, what an individual is doing out in a group is difficult, and then to remember exactly what that individual did as well, it might not be happening. You can move at the end of the city's case for a dismissal if you believe the city has failed to meet its burden. So stay alert to the possibility that they haven't met all the elements of the ordinance. And if not, you've got certainly the right to move orally to dismiss the case. As far as defense of presenting a defense at the trial, well, it's a fairly common way that you do it. You call your witnesses. So you've got the witnesses who have appeared or not, and you've got you control the order. Your client might already have been called by the city, so but you may want to call your client back up to address other issues that have arisen during the balance of the trial. I mentioned the fact there's no right against self-incrimination. Direct examination of your client. You can't ask leading questions, of course. You've got to ask open-ended questions. Prepare your client and your witnesses, the witnesses that you're going to call, prepare them to be cross-examined by the city attorney. So the general things that you'll be doing in preparing for a trial, you'll do in municipal court as well. Generally speaking, and then the city will have the right to put on some redirect evidence, so they'll have the opportunity to call witnesses back up, present other evidence if they wish, and of course you'll have the opportunity to put on additional evidence after that. But in terms of exhibits, you're likely to have some, and you'll want to have the clerk mark them ahead of time. So as we note here, you want the exhibits to be pre-marked, and you can coordinate that with the city attorney to see who's got which exhibits, and maybe both of you will have the same exhibits. But in any event, getting them marked ahead of time saves time. Everybody appreciates that. And the way you get them into evidence is a common way. Of course, the witness has to identify the exhibit and establish to the satisfaction of the judge that it's a fair and accurate depiction of something, or that it is actually something of relevance to the case, and you'll have to move that exhibit into evidence at the appropriate time. Generally speaking, the judge will make a decision at the end of all of the evidence, an oral decision. Occasionally, the judge will take a case under advisement in order to do a written decision. And I don't think that's going to happen, although with the protest cases, perhaps the judges will want to be a little more careful or will want to establish some precedent with a written opinion. But typically you can expect an oral decision at the conclusion of all the evidence, after you've made your closing argument, of course. So don't forget that that will come in as well. I want to just comment a little bit on the next slide about witnesses. If the city's witnesses do not appear, or a critical witness does not appear, you probably won't even have to move to dismiss. The city's going to move to dismiss because they have an inability to prove the case. In most cases, most situations, that dismissal will be without prejudice, meaning, of course, the city can start the case over again. Will they? Well, probably not. Most often the officers don't reissue a citation. Most often. Sometimes they will. You can move the court at that point to dismiss with prejudice. It's not going to happen very often, but if you have some facts to establish that it would really be unjust to try this case, to set this case again for trial, you can make that known to the judge, and on occasion you can get lucky and the judge will dismiss with prejudice. If your client's moving out of state, if there are witnesses that you brought in who were greatly inconvenienced and they're sitting there, they left their jobs, they're not going to get paid for the day, you can make a case that to put everybody through this again when the city's witnesses just didn't even show up is just not fair, and the judge ought to dismiss with prejudice. We mentioned, I'm going to come back to Kori on the fingerprint forms. The Zoom part, I think courts all over are getting used to using Zoom, and municipal court in Milwaukee is definitely moving toward that. I think we mentioned that on Monday. So you'll want to keep an eye on their website for any developments in that. Also, it's very easy to check online to see if your client has any outstanding warrants. The Milwaukee Municipal Court website allows you easily to navigate by name, and you can see if there are any outstanding warrants that your client has. You probably want to do this at the front end of things so that you're not walking into court and getting sandbagged with the news that your client has a warrant. It's quite easy to get the warrants released by you when you make an appearance for your client. So you don't need to run from those warrants. Some mention was made Monday about the substitute judges that come through, that some of them are not attorneys. So be aware of that. As far as the walk-in calendar, this whole pandemic mess limits your ability to simply walk into Milwaukee Municipal Court any day of the week and seek some relief from the judge or some action by the judge. Who knows when they'll get back to normal life, but when they do, there are hours in each morning and each afternoon when you can simply show up, check in at the reception window, and be seen by the judge with a motion, a request of some kind. It's very convenient, but unfortunately it's not available right now. And I don't know if or when they're going to get back to having something similar to a walk-in. You can certainly do these things now online or by letter and so on. As Kori indicated, filing items by fax, mail, some things online, eliminates the concern about the walk-in hours somewhat, but hopefully they'll get back to them. The Municipal Judge Bench Book is a great resource, and it tells you how the judges are thinking about things. So you can access that in the materials you've been given. So the Municipal Judge's Bench Book is a resource that the judges use and you can use as well. Kori, I'm going to punt to you the section here about fingerprints.
We're going to talk about fingerprint forms in more detail, Attorney London and I, on Friday, but just to a brief introduction, clients who are actually arrested for these curfew violations or disorderly conducts or other ordinance violations, if they're actually arrested and fingerprinted by law enforcement, a notation is going to be created, a cycle on their what's called their Crime Information Bureau background report that's maintained by the State Department of Justice. If you are successful in advocating for your client and getting this case dismissed, that arrest cycle is eligible to for removal from the report. And so we just want to remind folks that it can be very helpful at the onset of representation, if you do have a client who is fingerprinted, to obtain a fingerprint on the forms. And I believe they're in the materials that were provided, and we'll again talk about this on Friday. So you can send in a request to the DOJ to have that arrest cycle removed, so they can officially have, all, remnants of this arrest removed from their record, not just not having a conviction, but not having this show up when, they go apply for a job or they go look for housing or otherwise.
Good, thanks. I just wanted to mention one more thing on this slide. If you have subpoenaed a witness properly, that is, the judge signs this, issues the subpoena, signs it, and you serve the witness personally, you deliver the witness fee, and then that witness does not appear on the trial date, you can request that the judge adjourn the trial, or the judge can hear some of the evidence and adjourn for the balance from this witness, because you've done this properly, and it's a contempt of court for a properly subpoenaed witness not to appear without good cause. I mentioned this a little bit Monday, but this is the time at which you got to consider, do I want to ask the judge for a contempt finding against my witness who didn't show up, and for all I know, didn't have a good cause for failure to show up, and then have to come back another time to have that witness heard. So that's just something to keep in mind at the point you're in trial and you've subpoenaed a witness who didn't show. And that's what I have to say.
Great. And I think we have a couple questions related to that as well. We have one here. Do you need to have a hearing to request a subpoena from the judge, or do you fax, or can you mail in the request?
You can do the fax or mail. You just got to get your hands back on that. You got to get your hands on that signed copy. So, you know, you might send it in, well, I don't know about dropping it off, but in any event, get it to the judge and maybe provide a self-addressed stamped envelope to get the form back.
Absolutely. And then is the likely response to, when we were talking previously about requirements of a citation, when we were looking kind of at the face of the citation, is the likely response to a motion to dismiss for failure to provide an adequate description that the prosecutor just filed a citation, or the city attorney filed a citation with more specific just with a more specific description, or would they have to refile it, all over again, or how would that work?
Kori, do you have experience you'd like to describe first?
Well, I think practically what happens if you're successful in raising the sufficiency of the violation, I don't think I've ever had a ticket reissued. I think it really does depend on the prosecutor. At that point, if they want to pursue reissuing that, if the officer reissuing that citation, if I'm understanding the question correctly. So I think the practical result is typically a good one for the client. Jim, do you have?
I will describe an experience that I didn't appreciate. I had a case in another jurisdiction in Waukesha County, a municipal court there, where the prosecutor is a municipal judge in another court. So he prosecutes in that court, but he's a judge in his own court. And I raised with him as prosecutor the fact that the citation had nothing in the way of a description that's required by the statutes. And he acted as though that was a really strange observation for me to make, that it wasn't material and let's move forward. So I would say that not all judges think that that statutory requirement is significant as I think it is. So you might be prepared for that, where a judge says, I don't even need, I'm not going to do anything about this. It says on the citation, retail theft. The prosecutor certainly could ask the judge for an opportunity to get the citation amended, but then here's what you point out. Under the amendment provision at 800.025, the prosecutor has the right to amend the citation one time before the initial appearance without any request of the court or anything. So the prosecutor's already had a chance to look at the citation and amend it without any further ado before the initial appearance. So now the prosecutor's saying, well, Judge, I'd like a chance to amend the citation here. I would argue right back, Judge, there was that opportunity that this prosecutor had before today's appearance. So those would be my responses.
Great. And then we have a few questions. I'm trying to just kind of group them thematically here and in order of them. Does the city call the client when putting on a case, or wait till the defense case starts? In the trial, when we were discussing trial, I think this one came up.
Yeah. Typically, they will call the defendant adversely when they're presenting their case. So that's how they do it. They think they can get an admission or who knows what out of the defendant. So best to prepare your client for that happening.
And then how are videos handled? Are there DVD or some other way to play video? I mean, I guess, that'll be definitely impacted by, potentially Zoom, and virtual trials as well as we go forward. But how are they usually handled?
My experience with video, at least in Milwaukee, was not very sophisticated, to say. And it wasn't, obviously wasn't a curfew case. It was an OWI issue, a stop issue, looking at dash cam video. and it was put on the screen that's in front of us, so the witness could see it. So there was a screen in front by the prosecutor, and then I had made a copy of the video, and so the judge was able to see, play the DVD on his computer, and then it was just marked, the disc was marked as an exhibit. In other counties, I've done things as informally as holding up my computer screen. So I think it depends on where you're located. You should always contact the clerk and ask for their kind of technology ability. There are some counties that are far more advanced than others. But I'd always, either make a copy. I like to have video on both flash drive and CD, depending on what the capability of the court is. But it's good to call in advance. And I always bring everything you need, right? Bring an extra cord, HDMI, so if you do have to use your computer to make it work, that's not what's holding you back. But come with a couple copies and have checked in advance what the limitations might be in that court.
Fantastic. And then we have two more questions. Are there any notice requirements regarding expert witnesses specific to municipal court?
Certainly nothing statutory. I don't know, Kori, in your experience, if you've had a judge resist letting an expert testify because of no advance notice, but I don't think there's anything that restricts it, no.
No, and I think that what a judge would really, if someone really wanted to object to it, I think you would just be getting a judge that would probably just give you more time anyway. Well, if it's really an issue or you're really not prepared or it's really a surprise, I don't think there's anything that would stop it though, practically, statutorily.
And then serving a subpoena, again, for going back to subpoenas, for a judge to sign by mail with a return envelope, do you need to give a copy or notice to the other side as well?
Not at the point you obtain the subpoena from the judge. So there's no obligation to let the city know that you've approached the judge and obtained the judge's signature on a subpoena form, if that's where the question was directed.
Yes, I believe so. And correct me if I'm wrong if that didn't answer the question. But yeah, when you're serving the subpoena for the judge to sign, do you need to give that copy? Yeah.
Nope, no obligation to inform the city or municipality.
I'm just checking here to make sure there are no other questions that I missed here. Does anybody else have any questions? I think we got all of them, but feel free to reach out to me, and I'm happy to field those questions as much as possible and as accurately as possible if you have questions afterwards. Otherwise, I think we are at time, unless there were any other points that that you wanted to make.
I've said what I have to say today, I believe. I don't want to keep everybody from having their late lunch.
Wonderful, wonderful. Well, thank you all for attending. And again, part 3 is going to be this Friday, same time, 12 to 1, where we're going to be talking about some post-judgment issues related to municipal court. Again, if you have any issues with accessing the Google folder, we have all of this information on a CLE handout. I will be applying for CLE credit for each of these trainings, and you can access them there. If you have any issues with that, please feel free to reach out to me as well, and we'll get that all sorted out. Thank you so much for attending.